Who owns an unregistered trademark? And can anybody actually even own an unregistered trademark? Well, that depends on the country that you're in. In Australia and New Zealand, an unregistered trademark can be owned, and it's generally owned by the first person to use that trademark in that country. And very little use is required. So it could even be advertising your new range of clothing in a magazine, for example. That could be seen to be enough to give you the right of ownership of that trademark. It doesn't mean you can enforce it or stop others from using it, but it gives you enough rights so that you could get the trademark registered, and once it's registered, you could enforce it and stop others from using it. But what about the situation where the trademark is never used in Australia or New Zealand and it's only used overseas? Well, in that situation, the same applies. The first user here generally owns it, except if there's a relationship of trust. So, for example, if you went to the US and you saw an incredible range of donuts called Donut Magic, and you were talking to them about maybe being a franchisee here in Australia, and you came back and you're thinking about it, and then you decided, no, actually, I'm not going to go with these guys. They're too expensive. I'll just do it on my own. In that situation, if you then started using the name Donut Magic and try to register it as a trademark, you would be doing it in bad faith, because even though Donut Magic hasn't used it here, you know that it's their brand from overseas, and you've tried to get some kind of benefit for yourself when you had discussed being their franchisee. Now, if you went to the States and you saw Donut Magic and you thought it was wonderful and you wanted to use the same name here, but you never approached them, you never had discussions about being a franchisee in that situation, and provided they've never used the mark here in Australia, they've never advertised it here in Australia, in that situation, then you could theoretically get the trademark in Australia. Of course, the difficulty is that most businesses have websites these days. And so this part of the law relies on an old 7-Up case in the days before the internet, when 7-Up hadn't used 7-Up in Australia, and somebody wanted to register 8-Up, which is very similar to 7-Up, and clearly they were trying to trade off the reputation of 7-Up. But in that case, because 7-Up had never been used in Australia, the court said the Australian company could have the 8-Up trademark. But in these days, it would be very difficult to find a brand overseas that's not on the internet. And if it's on the internet and you could have accessed it from Australia, there would be an argument whether or not such use was Australian use. At least you could have been aware of it, or Australians could have been aware of the brand. So unless it's something really arcane, like a tiny little jeweler shop that's not on the internet, it's best to come up with your own brand rather than copying somebody else's. But what about the situation where you have an unregistered trademark that people are using, maybe collaborating and doing a collaboration, and 2 or 3 people are using the brand and nobody actually registers it? Who owns it then? Well, it's likely that a court would consider you all joint owners of that brand. And it's always best just to get it in writing. So a simple email to the others in your collaboration group saying, I know we're all collaborating on this project, just to let you know that this is my brand name and I own the rights to it, or I'm happy for us all to own the rights to this brand name, but if we disband, I would like to keep using it and you confirm that I own it, or just simply get the trademark registered, preferably in your own name, because that prevents issues from happening in the future. My name is Catherine Warburton, and I am the Legal Lioness.